Magna Carta History. Source: https://www.nationalarchives.gov.uk/education/resources/magna-carta-12151-1 The Magna Carta, Great Charter, is an 800-year-old document from Europe's Middle Ages, yet surprisingly it still has relevance in common law today. Sealed on the banks of the River Thames on the 15th of June 1215, the Magna Carta forms the foundation of our rights. Originally a treaty between King John of England and rebel barons, it's a document which over many centuries has shaped the exercise of power, the rights of the people, and the role of the law. Magna Carta is central to Australia's democratic foundations. Click image to view full size. From its beginning, the Commonwealth of Australia Constitution Act 1901 has been based on the Magna Carta's ideals of individual liberty and freedom, and the restraint of power. The Charter did not grant rights to anyone but simply recognised pre-existing inalienable natural liberties that the English had enjoyed long before the Normans conquered their island in 1066. Nevertheless, Magna Carta has been the basis of much of the body of law upholding our inherent rights and freedoms. Not surprisingly, kings and popes continually tried to nullify and ignore Magna Carta because of its attempt to restrict their power and uphold the sovereignty of the people. Shortly after the Charter's promulgation, Pope Innocent III issued a papal bull annulling it and threatening to excommunicate King John and all those who had signed it. Learn more here. The Pope cancels the Magna Carta, 1215. However, the 1215 Magna Carta is the only one we accept, as no Pope has any authority or jurisdiction to cancel a British law. The first Magna Carta was originally drawn up in 1215. However, it was quickly declared null and void by the Pope on the grounds it interfered with the authority of the king, and a civil war broke out. 1215 Magna Carta still stands in law today. Constitution Course. Common Law Courts. Constitution Court. However, the 1215 Magna Carta is the only one we accept, as no Pope has any authority or jurisdiction to cancel a British law.
Greetings, free people across the earth. Yeah, man. It says right here, no Pope has any authority or jurisdiction to cancel a British law. Then if no Pope can't cancel a British law, how can the Maroons come around here saying them cancel British law, which is the Jamaica Constitution, because it is a British law? Yeah, man. Are we not governed by a British crown? So these are the subtleties our people would miss. Why I bring this document forward is because this document set the precedent for what is common law here in this hemisphere. Yeah, man. Because we are under British governance only because we have a British head of state with a British militia / military force. So, honorable clarification. We can choose to adopt this 1215 document as our, law. Yeah, man. 'Cause is it not common law? And when I always I said there's common law and there's statutory law. And the statutory law for us encompass all of these commercial apartheid, where foreign people have dictate terms and tell you have to prove yourself innocent, because them are, consider you guilty. While under the common law, you're always innocent, where the foreign corporate construct will always have to prove you guilty, just like how they should always have to prove that they have jurisdiction. Again, honorable clarification from this sovereign West Indian. Yeah, man.
Law. The first Magna Carta was originally drawn up in 1215. However, it was quickly declared null and void by the Pope on the grounds it interfered with the authority of the king, and a civil war broke out in England. Following this, it was then reissued in various forms over the following years, resulting in yet another version issued in 1225. However, the original 1215 Magna Carta still stands in law today. Constitution Course. Common Law Courts. Common Law 101. Learn how to protect your rights. Click to enroll to learn. 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 Clause 61. The original 1215 version of Magna Carta had 63 clauses. Perhaps the most important of these is Clause 61, which says, "The barons shall elect 25 of their number to keep, and cause to be observed with all their might, the peace and liberties granted and confirmed to them by this charter. If we, our Chief Justice, our officials, or any of our servants offend in any respect against any man, or transgress any of the articles of the peace or of this security, and the offence is made known to 4 of the said 25 barons, they shall come to us, or in our absence from the kingdom to the Chief Justice, to declare it and claim immediate redress. If we, or in our absence abroad the Chief Justice, make no redress within 40 days, reckoning from the day on which the offence was declared to us or to him, the 4 barons shall refer the matter to the rest of the 25 barons, who may distrain upon and assail us in every way possible, with the support of the whole community of the land, by seizing our castles, lands, possessions, or anything else saving only our own person and those of the Queen and our children, until they have secured such redress as they have determined upon. Having secured the redress, they may then resume their normal obedience to us. Any man who so desires may take an oath to obey the commands of the 25 barons for the achievement of these ends, and to join with them in assailing us to the utmost of his power. Ever since it was signed, the Magna Carta has played a pivotal role in the rise of the English Parliament and the Commons as a self-governing body. It is the British Constitution. It also was foundational in the establishment of the United States Constitution and every international human rights convention since then. The arcane and historically specific provisions of much of the Charter does not distract from its continued ability to act as a counterweight against tyranny and arbitrary power. Magna Carta Libertatum, the Great Charter of Liberties. The first Great Charter of King John and the Barons granted 1215. Clauses marked plus were repeated in the Charter of 1225, but with minor changes. Clauses marked asterisk were omitted in all later reissues of the Charter. However, the 1215 Charter still stands as the bedrock of our rights and freedoms today. In the Charter itself, the clauses are not numbered, and the text reads continuously. John, by the grace of God, King of England, Lord of Ireland, Duke of Normandy and Aquitaine, and Count of Anjou, to his archbishops, bishops, abbots, earls, barons, justices, foresters, sheriffs, stewards, servants, and to all his officials and loyal subjects, greeting. know that before God, for the health of our soul and those of our ancestors and heirs, to the honor of God, the exaltation of the Holy Church, and the better ordering of our kingdom, at the advice of our Reverend Fathers Stephen, Archbishop of Canterbury, Primate of all England, and Cardinal of the Holy Roman Church, Henry Archbishop of Dublin, William Bishop of London, Peter Bishop of Winchester, Jocelyn Bishop of Bath and Glastonbury, Hugh Bishop of Lincoln, Walter Bishop of Worcester, William Bishop of Coventry, Benedict Bishop of Rochester, Master Pandulph Subdeacon and member of the Papal Household, Brother Aymeric Master of the Knighthood of the Temple in England, William Marshall Earl of Pembroke, William Earl of Salisbury, William Earl of Warren, William Earl of Arundel, Alan of Galloway Constable of Scotland, Warren Fitzgerald, Peter Fitzherbert, Hubert de Burgh Seneschal of Poitou, Hugh de Neville, Matthew Fitzherbert, Thomas Bassett, Alan Bassett, Philip d'Aubigny, Robert de Ropoli, John Marshall, John Fitzhugh, and other loyal subjects. +1. First, that we have granted to God, and by this present charter have confirmed for us and our heirs in perpetuity, that the English Church shall be free, and shall have its rights undiminished, and its liberties unimpaired. That we wish this so to be observed, appears from the fact that of our own free will, before the outbreak of the present dispute between us and our barons, we granted and confirmed by charter the freedom of the Church's elections, a right reckoned to be of the greatest necessity and importance to it, and caused this to be confirmed by Pope Innocent III. This freedom we shall observe ourselves, and desire to be observed in good faith by our heirs in perpetuity. To all free men of our kingdom we have also granted, for us and our heirs forever, all the liberties written out below, to have and to keep for them and their heirs, of us and our heirs. 2. If any earl, baron, or other person that holds lands directly of the crown, for military service, shall die, and at his death his heir shall be of full age and owe a relief, the heir shall have his inheritance on payment of the ancient scale of relief. That is to say, the heir or heirs of an earl shall pay £100 for the entire earl's barony, the heir or heirs of a knight 100s. At most for the entire knight's fee, and any man that owes less shall pay less, in accordance with the ancient usage of fees. 3. But if the heir of such a person is under age in a ward, when he comes of age he shall have his inheritance without relief or fine. 4. The guardian of the land of an heir who is under age shall take from it only reasonable revenues, customary dues, and feudal services. He shall do this without destruction or damage to men or property. If we have given the guardianship of the land to a sheriff, or to any person answerable to us for the revenues, and he commits destruction or damage, we will exact compensation from him, and the land shall be entrusted to 2 worthy and prudent men of the same fee, who shall be answerable to us for the revenues, or to the person to whom we have assigned them. If we have given or sold to anyone the guardianship of such land, and he causes destruction or damage, he shall lose the guardianship of it, and it shall be handed over to 2 worthy and prudent men of the same fee, who shall be similarly answerable to us. 5. For so long as a guardian has guardianship of such land, he shall maintain the houses, parks, fish preserves, ponds, mills, and everything else pertaining to it, from the revenues of the land itself. When the heir comes of age, he shall restore the whole land to him, stocked with plough teams and such implements of husbandry as the season demands and the revenues from the land can reasonably bear. 6. Heirs may be given in marriage, but not to someone of lower social standing. Before a marriage takes place, it shall be made known to the heirs next of kin. 7. At her husband's death, a widow may have her marriage portion and inheritance at once and without trouble. She shall pay nothing for her dower, marriage portion, or any inheritance that she and her husband held jointly on the day of his death. She may remain in her husband's house for 40 days after his death, and within this period her dower shall be assigned to her. 8. No widow shall be compelled to marry, so long as she wishes to remain without a husband. But she must give security that she will not marry without royal consent, if she holds her lands of the crown, or without the consent of whatever other lord she may hold them of. 9. Neither we nor our officials will seize any land or rent in payment of a debt, so long as the debtor has movable goods sufficient to discharge the debt. A debtor's sureties shall not be distrained upon so long as the debtor himself can discharge his debt. If, for lack of means, the debtor is unable to discharge his debt, his sureties shall be answerable for it. If they so desire, they may have the debtor's lands and rents until they have received satisfaction for the debt that they paid for him, unless the debtor can show that he has settled his obligations to them. Asterisk 10. If anyone who has borrowed a sum of money from Jews dies before the debt has been repaid, his heir, irrespective of whom he holds his, irrespective Magna Carta History. Nine. Neither we nor our officials will seize any land or rent in payment of a debt, so long as the debtor has movable goods sufficient to discharge the debt. A debtor's sureties shall not be distrained upon so long as the debtor himself can discharge his debt. If, for lack of means, the debtor is unable to discharge his debt, his sureties shall be answerable for it. If they so desire, they may have the debtor's lands and rents until they have received satisfaction for the debt that they paid for him, unless the debtor can show that he has settled his obligations to them. Asterisk 10. If anyone who has borrowed a sum of money from Jews dies before the debt has been repaid, his heir shall pay no interest on the debt for so long as he remains under age, irrespective of whom he holds his lands. If such a debt falls into the hands of the Crown, it will take nothing except the principal sum specified in the bond. Asterisk 11. If a man dies owing money to Jews, his wife may have her dower and pay nothing towards the debt from it. If he leaves children that are under age, their needs may also be provided for on a scale appropriate to the size of his holding of lands. The debt is to be paid out of the residue, reserving the service due to his feudal lords. Debts owed to persons other than Jews are to be dealt with similarly. Asterisk 12. No scutage or aid may be levied in our kingdom without its general consent, unless it is for the ransom of our person, to make our eldest son a knight, and, once, to marry our eldest daughter. For these purposes only a reasonable aid may be levied. Aids from the City of London are to be treated similarly. Plus, 13. The City of London shall enjoy all its ancient liberties and free customs, both by land and by water. We also will and grant that all other cities, boroughs, towns, and ports shall enjoy all their liberties and free customs. Asterisk 14. To obtain the general consent of the realm for the assessment of an aid, except in the 3 cases specified above, or a scutage, we will cause the archbishops, bishops, abbots, earls, and greater barons to be summoned individually by letter. To those who hold lands directly of us we will cause a general summons to be issued, through the sheriffs and other officials, to come together on a fixed day, of which at least 40 days' notice shall be given, and at a fixed place. In all letters of summons, the cause of the summons will be stated. When a summons has been issued, the business appointed for the day shall go forward in accordance with the resolution of those present, even if not all those who were summoned have appeared. Asterisk 15. In future we will allow no one to levy an aid from his free men, except to ransom his person, to make his eldest son a knight, and, once, to marry his eldest daughter. For these purposes only a reasonable aid may be levied. 16. No man shall be forced to perform more service for a knight's fee, or other freeholding of land, than is due from it. 17. Ordinary lawsuits shall not follow the royal court around, but shall be held in a fixed place. 18. Inquests of novel disseisin, mort d'ancestor, and darrein presentment shall be taken only in their proper county court. We ourselves, or in our absence abroad our Chief Justice, will send 2 justices to each county 4 times a year, and these justices, with 4 knights of the county elected by the county itself, shall hold the assizes in the county court, on the day and in the place where the court meets. 19. If any assizes cannot be taken on the day of the county court, as many knights and freeholders shall afterwards remain behind, of those who have attended the court, as will suffice for the administration of justice, having regard to the volume of business to be done. 20. For a trivial offence, a free man shall be fined only in proportion to the degree of his offence, and for a serious offence correspondingly, but not so heavily as to deprive him of his livelihood. In the same way, a merchant shall be spared his merchandise, and a villain the implements of his husbandry, if they fall upon the mercy of a royal court. None of these fines shall be imposed except by the assessment on oath of reputable men of the neighbourhood. 21. Earls and barons shall be fined only by their equals, and in proportion to the gravity of their offence. 22. A fine imposed upon the lay property of a clerk in holy orders shall be assessed upon the same principles, without reference to the value of his ecclesiastical benefice. 23. No town or person shall be forced to build bridges over rivers except those with an ancient obligation to do so. 24. No sheriff, constable, coroners, or other royal officials are to hold lawsuits that should be held by the royal justices. Asterisk 25. Every county, hundred, wapentake, and tithing shall remain at its ancient rent, without increase, except the royal domain manors. 26. If at the death of a man who holds a lay fee of the crown, a sheriff or royal official produces royal letters patent of summons for a debt due to the crown, it shall be lawful for them to seize and list movable goods found in the lay fee of the dead man to the value of the debt, as assessed by worthy men. Nothing shall be removed until the whole debt is paid, when the residue shall be given over to the executors to carry out the dead man's will. If no debt is due to the crown, all the movable goods shall be regarded as the property of the dead man, except the reasonable shares of his wife and children. Asterisk 27. If a free man dies intestate, his movable goods are to be distributed by his next of kin and friends, under the supervision of the church. The rights of his debtors are to be preserved. 28. No constable or other royal official shall take corn or other movable goods from any man without immediate payment, unless the seller voluntarily offers postponement of this. 29. No constable may compel a knight to pay money for castle guard if the knight is willing to undertake the guard in person, or with reasonable excuse to supply some other fit man to do it. A knight taken or sent on military service shall be excused from castle guard for the period of this service. 30. No sheriff, royal official, or other person shall take horses or carts for transport from any free man, without his consent. 31. Neither we nor any royal official will take wood for our castle, or for any other purpose, without the consent of the owner. 32. We will not keep the lands of people convicted of felony in our hand for longer than a year and a day, after which they shall be returned to the lords of the fees concerned. 33. All fisheries shall be removed from the Thames, the Medway, and throughout the whole of England, except on the sea coast. 34. The writ called precipice shall not in future be issued to anyone in respect of any holding of land, if a free man could thereby be deprived of the right of trial in his own lord's court. 35. There shall be standard measures of wine, ale, and corn, the London quarter, throughout the kingdom. There shall also be a standard width of dyed cloth, russet, and haberjacked, namely 2 ells within the selvages. Weights are to be standardized similarly. 36. In future nothing shall be paid or accepted for the issue of a writ of inquisition of life or limbs. It shall be given gratis, and not refused. 37. If a man holds land of the crown by fee farm, soccage, or burgage, and also holds land of someone else for knight service, we will not have guardianship of his heir, nor of the land that belongs to the other person's fee, by virtue of the fee farm, soccage, or burgage, unless the fee farm owes knight service. We will not have the guardianship of a man's heir, or of land that he holds of someone else, by reason of any small property that he may hold of the crown for a service of knives, arrows, or the like. 38. In future no official shall place a man on trial upon his own unsupported statement, without producing credible witnesses to the truth of it. Plus, 39. No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals or by the law of the land. Plus, 40. To no one will we sell, to no one deny or delay right or justice. 41. All merchants may enter or leave England unharmed and without fear, and may stay or travel within it, by land or water, for purposes of trade, free from all illegal exactions, in accordance with ancient and lawful customs. This, however, does not apply in time of war to merchants from a country that is at war with us. Any such merchants found in our country at the outbreak of war shall be detained without injury to their persons or property, until we or our Chief Justice have discovered how our own merchants are being treated in the country at war with us. If our own merchants are safe, they shall be safe too. Asterisk 42. In future it shall be lawful for any man to leave and return to our kingdom unharmed and without fear, by land or water, preserving his allegiance to us, except in time of war, for some short period, for the common benefit of the realm. People that have been imprisoned or outlawed in accordance with the law of the land, people from a country that is at war with us, and merchants, who shall be dealt with as stated above, are excepted from this provision. 43. If a man holds lands of any estate such as the honour of Wallingford, Nottingham, Boulogne, Lancaster, or of other estates in our hand that are baronies, at his death his heir shall give us only the relief and service that he would have made to the baron, had the barony been in the baron's hand. We will hold the estate in the same manner as the baron held it. 44. People who live outside the forest need not in future appear before the royal justices of the forest in answer to general summonses, unless they are actually involved in proceedings or are sureties for someone who has been seized for a forest offence. Asterisk 45. We will appoint as justices, constables, sheriffs, or other officials, only men that know the law of the realm and are minded to keep it well. 46. All barons who have founded abbeys, and have charters of English kings or ancient tenure as evidence of this, may have guardianship of them when there is no abbot, as is their due. 47. All forests that have been created in our reign shall at once be disafforested. River banks that have been enclosed in our reign shall be treated similarly. Asterisk 48. All evil customs relating to forests and warrens, foresters, warreners, sheriffs, and their servants, or river banks and their wardens, are at once to be investigated in every county by 12 sworn knights of the county, and within 40 days of their inquiry the evil customs are to be abolished completely and irrevocably. But we, or our Chief Justice if we are not in England, are first to be informed. Asterisk 49. We will at once return all hostages and charters delivered up to us by Englishmen as security for peace or for loyal service. Asterisk 50. We will remove completely from their offices the kinsmen of Gerard de Athy, and in future they shall hold no offices in England. The people in question are Engelard de Sigogny, Peter, Guy, and Andrew de Chanceaux, Guy de Sigogny, Geoffrey de Martigny and his brothers, Philip Mark and his brothers, with Geoffrey his nephew, and all their followers. Asterisk 51. As soon as peace is restored, we will remove from the kingdom all the foreign knights, bowmen, their attendants, and the mercenaries that have come to it, to its harm, with horses and arms. Asterisk 52. To any man whom we have deprived or dispossessed of lands, castles, liberties, or rights, without the lawful judgment of his equals, we will at once restore these. In cases of dispute the matter shall be resolved by the judgment of the 25 barons referred to below in the clause for securing the peace, section 61. In cases, however, where a man was deprived or dispossessed of something without the lawful judgment of his equals by our father King Henry or our brother King Richard, and it remains in our hands or is held by others under our warranty, we shall have respite for the period commonly allowed to crusaders, unless a lawsuit had been begun, or an inquiry had been made at our order, before we took the cross as a crusader. On our return from the crusade, or if we abandon it, we will at once render justice in full. 53. We shall have similar respite in rendering justice in connection with forests that are to be disafforested, or to remain forests, when these were first afforested by our father Henry or our brother Richard, with the guardianship of lands in another person's fee, when we have hitherto had this by virtue of a fee held of us for knight service by a third party, and with abbeys founded in another person's fee, in which the lord of the fee claims to own a right. On our return from the crusade, or if we abandon it, we will at once do full justice to complaints about these matters. 54. No one shall be arrested or imprisoned on the appeal of a woman for the death of any person except her husband. 55. All fines that have been given to us unjustly and against the law of the land, and all fines that we have exacted unjustly, shall be entirely remitted or the matter decided by a majority judgment of the 25 barons referred to below in the clause for securing the peace, section 61, together with Stephen, Archbishop of Canterbury, if he can be present, and such others as he wishes to bring with him. If the Archbishop cannot be present, proceedings shall continue without him, provided that if any of the 25 barons has been involved in a similar suit himself, his judgment shall be set aside, and someone else chosen and sworn in his place, as a substitute for the single occasion, by the rest of the 25. 56. If we have deprived or dispossessed any Welshman of land, liberties, or anything else in England or in Wales, without the lawful judgment of their equals, these are at once to be returned to them. A dispute on this point shall be determined in the marches by the judgment of equals. English law shall apply to holdings of land in England, Welsh law to those in Wales, and the law of the marches to those in the marches. The Welsh shall treat us and ours in the same way. 57. In cases where a Welshman was deprived or dispossessed of anything, without the lawful judgment of his equals, by our father King Henry or our brother King Richard, and it remains in our hands or is held by others under our warranty, we shall have respite for the period commonly allowed to crusaders, unless a lawsuit had been begun, or an inquiry had been made at our order, before we took the cross as a crusader. But on our return from the crusade, or if we abandon it, we will at once do full justice according to the laws of Wales and the said regions. 58. We will at once return the son of Llywelyn, all Welsh hostages, and the charters delivered to us as security for the peace. 59. With regard to the return of the sisters and hostages of Alexander, King of Scotland, his liberties, and his rights, we will treat him in the same way as our other barons of England, unless it appears from the charters that we hold from his father William, formerly King of Scotland, that he should be treated otherwise. This matter shall be resolved by the judgment of his equals in our court. 60. All these customs and liberties that we have granted shall be observed in our kingdom in so far as concerns our own relations with our subjects. Let all men of our kingdom, whether clergy or laymen, observe them similarly in their relations with their own men. 61. Since we have granted all these things for God, for the better ordering of our kingdom, and to allay the discord that has arisen between us and our barons, and since we desire that they shall be enjoyed in their entirety, with lasting strength, forever, we give and grant to the barons the following security. The barons shall elect 25 of their number to keep, and cause to be observed with all their might, the peace and liberties granted and confirmed to them by this charter. If we, our Chief Justice, our officials, or any of our servants offend in any respect against any man, or transgress any of the articles of the peace or of this security, and the offence is made known to 4 of the said 25 barons, they shall come to us, or in our absence from the kingdom to the Chief Justice, to declare it and claim immediate redress. If we, or in our absence abroad the Chief Justice, make no redress within 40 days, reckoning from the day on which the offence was declared to us or to him, the 4 barons shall refer the matter to the rest of the 25 barons, who may distrain upon and assail us in every way possible, with the support of the whole community of the land, by seizing our castles, lands, possessions, or anything else saving only our own person and those of the Queen and our children, until they have secured such redress as they have determined upon. Having secured the redress, they may then resume their normal obedience to us. Any man who so desires may take an oath to obey the commands of the 25 barons for the achievement of these ends, and to join with them in assailing us to the utmost of his power. We give public and free permission to take this oath to any man who so desires, and at no time will we prohibit any man from taking it. Indeed, we will compel any of our subjects who are unwilling to take it to swear it at our command. If one of the 25 barons dies or leaves the country, or is prevented in any other way from discharging his duties, the rest of them shall choose another baron in his place, at their discretion, who shall be duly sworn in as they were. In the event of disagreement among the 25 barons on any matter referred to them for decision, the verdict of the majority present shall have the same validity as a unanimous verdict of the whole 25, whether these were all present or some of those summoned were unwilling or unable to appear. The 25 barons shall swear to obey all the above articles faithfully, and shall cause them to be obeyed by others to the best of their power. We will not seek to procure from anyone, either by our own efforts or those of a third party, anything by which any part of these concessions or liberties might be revoked or diminished. Should such a thing be procured, it shall be null and void, and we will at no time make use of it, either ourselves or through a third party. Asterisk 62. We have remitted and pardoned fully to all men any ill will, hurt, or grudges that have arisen between us and our subjects, whether clergy or laymen, since the beginning of the dispute. We have in addition remitted fully, and for our own part have also pardoned, to all clergy and laymen any offences committed as a result of the said dispute between Easter in the 16th year of our reign, i.e. 1215, and the restoration of peace. In addition, we have caused letters patent to be made for the barons, bearing witness to this security and to the concessions set out above, over the seals of Stephen Archbishop of Canterbury, Henry Archbishop of Dublin, the other bishops named above, and Master Pandulph. Asterisk 63. It is accordingly our wish and command that the English Church shall be free, and that men in our kingdom shall have and keep all these liberties, rights, and concessions, well and peaceably in their fullness and entirety for them and their heirs, of us and our heirs, in all things and all places forever. Both we and the barons have sworn that all this shall be observed in good faith and without deceit. Witness the above-mentioned people and many others. Given by our hand in the meadow that is called Runnymede, between Windsor and Staines, on the 15th day of June in the 17th year of our reign, i.e. 1215, the new regnal year began on the 28th of May. Security clause invoked. Defend the Realm by Jackie Phoenix. Click to view full size. On the 23rd of March 2001, the Barons Committee invoked Article 61 of Magna Carta 1215 due to treason at the highest levels of government. Magna Carta 1215 is our forever binding English and Commonwealth Constitution. It is in place to maintain and uphold the rule of law and protects our right to justice. The monarch has a duty as the head of state to uphold our Constitution. When a monarch fails to uphold the Constitution and the rule of law is usurped, the Barons Committee have a duty to invoke the security clause that protects the people. Once the security clause has been invoked, all members of the public throughout the Commonwealth have a constitutional duty to seize all public buildings, giving them a lawful, peaceful way to restore the rule of law that protects the people. the 23rd of March 2001, the Barons Committee invoked Article 61 of Magna Carta 1215 due to treason at the highest levels of government. Magna Carta 1215 is our forever binding English and Commonwealth Constitution. It is in place to maintain and uphold the rule of law and protects our right to justice. The monarch has a duty as the head of state to uphold our Constitution. When a monarch fails to uphold the Constitution and the rule of law is usurped, the Barons Committee have a duty to invoke the security clause that protects the people. Once the security clause has been invoked, all members of the public throughout the Commonwealth have a constitutional duty to seize all public buildings, giving them a lawful, peaceful way to restore the rule of law that protects the people. The martial The Martial Court, 1801 to 1835. My gift of John Marshall to the people of the United States was the proudest act of my life. John Adams, President. Marshall skillfully asserted the court's mightiest power and dignity in its first great crisis. In Congress, the lame duck Federalists had passed a law to reduce the court's membership to 5, one less justice for a Republican president to name. Abolishing circuit duties for the justices and providing other reforms, this law set up new circuit courts with 16 judges. Before leaving office, Adams had quickly named his judicial appointees, the famous midnight judges. Enraged, one Republican from Kentucky called Adams's tactics the last effort of the most wicked, insidious, and turbulent faction that ever disgraced our political annals. Jefferson took the oath of office on March 4, 1801. Without precedents and with passions running high, the presidency and the Congress passed for the first time from one party to another. And some citizens were afraid that the judiciary was in mortal danger. Soon after his inauguration, Jefferson wrote that the Federalists had retreated into the judiciary as a stronghold, the tenure of which renders it difficult to dislodge them. But the Republicans repealed the Lame Duck Judiciary Act, while horrified Federalists lamented, "The Constitution has received a wound it cannot long survive, and the angels of destruction are making haste." Meanwhile, William Marbury of Washington went straight to the Supreme Court, looking for a commission as Justice of the Peace for the District of Columbia. Adams had appointed 42 such officials, the Senate frantically confirmed them, and Adams sat at his desk until late on his last night in office to sign their commissions. Then a messenger rushed the papers to the State Department for Marshall, still acting as secretary, to affix the Great Seal of the United States. In the confusion, some of the commissions went undelivered, Marbury's among them. In December 1801, Marbury applied to the court for a writ of mandamus ordering James Madison, the new Secretary of State, to give him his commission. The court agreed to hear the case, a bold action, for rumor was saying the justices must fall by impeachment. Then the Republican Congress repealed the Judiciary Act of 1801, which mandated sessions in December and June, and eliminated the August term of the court. As a result, the justices did not sit from April 1802 to February 1803, when they heard argument in Marbury's case. If the court ordered Madison to produce that commission, he could simply ignore the order. President Jefferson would defend him. If the court denied Marbury's right to his commission, Jefferson could claim a party victory. Either way, the court's prestige, and perhaps its members, must fall. Marshall found an escape from his dilemma. He announced the decision on February 24th, and proclaimed the most distinctive power of the Supreme Court, the power to declare an act of Congress unconstitutional. Point by point he analyzed the case. Did Marbury have a legal right to his commission? Yes. Would a writ of mandamus enforce his right? Yes. Could the court issue the writ? No. Congress had said it could, in the Judiciary Act of 1789. It had given the court an original jurisdiction in such cases, power to try them for the first time. But, said Marshall triumphantly, the Constitution defined the court's original jurisdiction and Congress could not change it by law. Therefore that section of the law was void. Marshall declared for all time the supremacy of the Constitution over any conflicting law. Other judges had said as much, but Marshall added, "It is, emphatically, the province and duty of the judicial department to say what the law is." In renouncing a minor jurisdiction, he asserted a great one, perhaps the greatest in the long annals of the law. The Supreme Court's power as interpreter of the Constitution rests on this precedent to this day. A few days after the decision in Marbury v. Madison, the court again amazed the Jeffersonians. They had passed a Judiciary Act in Congress, restoring the court's old membership and circuit duties. The justices ruled that it was constitutional, and for a while talk of impeachment died down. The justices are seated on the dais on the far side of the chamber in this evening session of the House of Representatives, circa 1822. The Corcoran Gallery of Art. Oh yes! Oh yes! Oh yes! The Grand Inquest of the Nation is exhibiting to the Senate articles of impeachment against Samuel Chase, Associate Justice. The Supreme Court was on trial. If Chase fell, Marshall might be next. Feared as a ringleader of mobs, a foul-mouthed and inflaming son of discord when he led the Sons of Liberty in 1765, Chase was forever getting into some unnecessary squabble as a judge 40 years later. He campaigned openly for Adams. On circuit he tried Republicans without mercy. In 1803 he told a Baltimore grand jury that modern doctrines of equal liberty and equal rights were sinking the Constitution into a mobocracy, the worst of all popular governments. His enemies saw their chance. The House of Representatives voted to bring him before the Senate for trial, charging that his partisan behavior in and out of court amounted to high crimes and misdemeanors under the Constitution. Vice President Aaron Burr had arranged a special gallery for ladies when the Grand Inquest opened on February 4, 1805. Burr had killed Alexander Hamilton in a duel and New Jersey wanted him for murder, but he presided sternly, rebuking senators who were eating cake and apples. "We are indeed fallen on evil times," said one. "The high office of president is filled by an infidel, that of vice president by a murderer." Representative John Randolph of Roanoke, the brilliant, erratic Virginian, fought to prove Chase unfit for the court. Luther Martin of Maryland, who could hold more law and more brandy than any other attorney of his time, led Chase's defense. Marshall and 51 other witnesses testified. Amid a vast concourse of people and great solemnity, the senators acquitted Chase on March 1st. Jefferson called impeachment of justices a farce which will not be tried again, and he was right. For all his differences with the Republicans, John Marshall was no son of discord. Born in a log cabin near Germantown, Virginia, in 1755, he grew up near the frontier, with some tutoring for an education. He fought as an officer in the Revolution, almost freezing at Valley Forge. After the war he practiced law, and became the leading Federalist of his state. As a young attorney and an aging Chief Justice, he was sloppily dressed and wonderfully informal out of court, fond of spending hours with friends in taverns, law offices, and drawing rooms. Even in his 60s, Marshall was still one of the best quoits players in Virginia. When the court met in Washington, the justices stayed in a boarding house. The trip was too long, the session too short for their wives to accompany them, and Marshall's geniality brightened their off-duty hours. A disheveled Chief Justice Marshall, in torn breeches, at left, was elegant in speech as he chatted in taverns while riding circuit. Library of Congress. Justice Joseph Story handed down a tale still told at the court. On rainy days the judges would enliven their conferences with wine. On other days Marshall might say, "Brother Story, step to the window and see if it doesn't look like rain." If the sun was shining, Marshall would order wine anyway, since our jurisdiction is so vast that it might be raining somewhere. Congress expanded that domain in 1807, creating a new circuit for Kentucky, Tennessee, and Ohio, and adding a seat to the court. Jefferson appointed Thomas Todd, who had helped create the state of Kentucky out of his native Virginia. Life in Washington went on peacefully for months during the War of 1812. Mrs. Madison and a train of ladies visited the Supreme Court one day in early 1814, just as William Pinckney of Maryland, one of the country's most celebrated lawyers, was ending an argument. He recommenced, went over the same ground, using fewer arguments, but scattering more flowers. Rudely interrupting such diversions, the British arrived in August and burned the Capitol. Congress found shelter in the makeshift brick Capitol where the Supreme Court building stands today. The court, forced to shift for itself, met for a while in a house on Pennsylvania Avenue. Then it got temporary space in the Capitol. In 1819 it returned to its own semicircular room below the Senate chamber. A stranger might traverse the dark avenues of the Capitol for a week, reported a visitor from New York, without finding the remote corner in which justice is administered to the American Republic. Strangers traversing the Republic had other troubles. I passed away my $20 note of the Rotten Bank of Harmony, Pennsylvania, for $5 only, a disgusted traveler complained at Vincent's, Indiana. State-chartered banks, private banks, towns, sawmills, counterfeiters all issued notes freely. Engravings, a Scotsman called them, no law required anyone to accept them at face value as legal tender. Everyone suffered from this chaos. Congress had chartered the Second Bank of the United States in 1816 to establish a sound national currency, to issue notes it would redeem in gold or silver. By law, the government owned a fifth of the bank's stock and named a fifth of its directors. Private investors had the rest. Unscrupulous characters got control of the bank and mismanaged its affairs. In the South and West, where engravings flourished, the bank's branches made bad loans until the Home Office at Philadelphia issued new orders in August 1818. Call in those loans. Don't accept any payments but gold and silver or our own notes. Panic spread. Local banks demanded payment on their own loans and refused to extend credit. People scrambled for money they couldn't find. Land went for a song at sheriff's auctions. Shops closed. Men who lost their last $5 said bitterly, "The bank saved and the people are ruined." State legislators decided to drive the bank's branches out of their domain. Maryland passed a tax law giving the Baltimore branch its choice: pay up handsomely or give up and leave. The branch ignored it. Maryland sued the cashier, James McCulloch, and won in its own courts. McCulloch took his case, that is, the banks, to the Supreme Court where argument began on February 22, 1819. Splendid in his blue coat with big brass buttons, Daniel Webster spoke for the bank. Congress has power to charter it. Maryland has no power to tax it, for the power to tax involves a power to destroy, and never under the Constitution may the states tax the Union into destruction. The Supreme Court affirmed the legitimacy of the Bank of the United States, depicted here as a large woman vomiting coins to state banks, when Maryland mounted a challenge in 1819. Library of Congress. Luther Martin, Maryland's Attorney General, argued for his state. Where does the Constitution say Congress has power to create a national bank? He asked. Nowhere. He thundered. It lists specific powers, and making banks is not one of them. Mr. Webster says it implies such a power. Nonsense. For the court, Marshall defined the controversy: a sovereign state denies the obligation of a law of the Union. An awful question, but it must be decided peacefully. Because the Union is emphatically and truly a government of the people, it must prevail over the states. To specific powers of Congress, the Constitution adds powers to make all laws necessary and proper for carrying them into effect. Marshall invoked letter and spirit to give that clause its meaning. Let the end be legitimate, let it be within the scope of the Constitution, and Congress may use all means which are appropriate, which are not prohibited. So the bank was constitutional, no state might tax it. Maryland's law was unconstitutional and void. The court's ruling settled the conflict of law but not the political fight over the bank's power and states' rights. Virginia's legislature made a most solemn protest against the decision in McCulloch v. Maryland. Ohio officials took money by force from one bank branch. Not until President Andrew Jackson vetoed the bank's recharter did that controversy die down. States' rights against the powers of the Union. The issue became more explosive than ever when the country faced its first great quarrel over slavery, in 1819. Southerners in Congress threatened secession and civil war. A Georgian foresaw our houses wrapped in flames. When the House was discussing a bill to make Missouri Territory a state, a New York representative suggested that Congress forbid slavery there. Southerners warned, the Union will be dissolved. The reply flashed, let it be so. For months the furious debate went on. Then, in February 1820, Senator Jesse B. Thomas of Illinois offered a compromise: Maine to be a free state, Missouri a slave state, and the rest of the Louisiana Purchase north of 36 feet 30 inches free soil forever. Henry Clay supported the plan. Early in March, President James Monroe signed the laws to carry it out. Apparently the crisis was over. But trouble flared again as Congress debated Missouri's proposed constitution and states' rights in general, and what had been a trivial criminal case quickly became a rallying point for states' rights advocates and proponents of secession. In Norfolk, Virginia, P.J. and M.J. Cohen were charged with violating a state law by selling 6 tickets in a lottery established by Congress to pay for improvements in the District of Columbia. The law forbade all lotteries except the state's own. A Norfolk court convicted the Cohens. They turned to the Supreme Court, pointing out that their lottery tickets were authorized by federal law. Virginia rose in wrath. Her General Assembly declared that the court had no jurisdiction. Her lawyers fought the Cohens' request for a hearing. They warned the Supreme Court against exciting the hostility of the state governments, which would decide how long the Union should endure. Then, in March 1821, a second compromise was reached, bringing Missouri into the Union 5 months later as a slave state, but with guarantees designed to protect the rights of free Negroes and mulattoes. The issues of slavery and secession subsided, eventually to be resolved in blood. Undeterred by the impassioned controversy, Marshall gave an uncompromising ruling in Cohens v. Virginia. The court would hear the case. It existed to resolve such clashings of state and union power, to keep the national government from becoming a mere shadow. Insisting on the power of his court, the Chief Justice boldly met the threat of secession and the claims of state sovereignty. He upheld the Union as the supreme government of the whole American people. Then the court heard argument on the merits of the case and affirmed the sentence of the Norfolk court. The Cohens lost $100, their fine, and costs. Southerners fumed at Marshall's stand in the Cohens case. But in 1824, for once, a Marshall ruling met popular acclaim. Huzzahs from the walls greeted the steamboat United States as she chuffed triumphantly into New York Harbor, her crew firing a salute, her passengers exulting in the decision of the United States Supreme Court. That case was Gibbons v. Ogden. Robert Fulton successfully demonstrated a steam-powered vessel on the Seine at Paris in 1803. With his partner, Robert R. Livingston, he held an exclusive right from New York's legislature to run steamboats on state waters, including New York Harbor and the Hudson River. In 1807, his steamer splashed up the Hudson to Albany. Soon money flowed into their pockets. Anyone else who wanted to run steamboats on those waters had to pay them for the privilege. Some Albany men attacked the monopoly in state courts and lost. In 1811, the territorial legislature in New Orleans gave the partners a monopoly on the Mississippi. Now they controlled the two greatest ports in the country. New Jersey passed a law allowing its citizens to seize steamboats owned by New Yorkers. Other states enacted monopolies and countermeasures until the innocent side wheeler was turning into a battleship. Meanwhile, three men of property went into business, then into rages, then into court. Robert Livingston's brother John bought rights in New York Bay. Then he sublet his waters to former Governor Aaron Ogden of New Jersey, a quarrelsome lawyer. Ogden took a partner, Thomas Gibbons, equally stubborn and hot-tempered. Under an old act of Congress, Gibbons had licensed 2 steamboats for the national coasting trade, and now he invoked this federal law to get a suit against Ogden before the Supreme Court. The once obscure Supreme Court was now a focus of public interest. Ladies crowded lawyers to hear the case. Daniel Webster spoke for Gibbons on February 4, 1824. Ogden's attorneys quoted established law and precedents for 2 days. But Marshall avoided shoals of precedents and veering winds of state laws to set his course by the Constitution, the clause giving Congress power to regulate commerce among the states. For the first time, the court defined these words. In them, Marshall found vast new currents of national strength. More than buying and selling, he proclaimed, commerce is intercourse among nations and states. It includes navigation. For all this rich activity, Congress may make rules. If its rules collide with state restrictions, the latter must sink. New York's law went down before an act of Congress. State monopolies could not scuttle ships propelled by the agency of fire. Steamboats would be as free as vessels wafted on their voyage by the winds. With monopolies swept away, steamboat trade spread fast and freely. Soon, by that precedent, steam cars on rails spread across state lines, across the continent. Marshall watched as changes came and went. We must never forget, he said, that it is a constitution we are expounding, a constitution intended to endure for ages to come, and consequently, to be adapted to the various crises of human affairs. His actions made his words unforgettable. When Marshall gave the presidential oath to his cousin Thomas Jefferson in 1801, the Supreme Court was a fortress under attack. It had become a shrine when he gave the oath to Andrew Jackson in 1829. The court's ruling settled the conflict of law but not the political fight over the bank's power and states' rights. Virginia's legislature made a most solemn protest against the decision in McCulloch v. Maryland. Ohio officials took money by force from one bank branch. Not until President Andrew Jackson vetoed the bank's recharter did that controversy die down. New crises arose during Jackson's administration. Marshall carried on his work, concerned for the country's future but not for his failing health. Jay had resigned after 5 years, Ellsworth after 4. Marshall served from 1801 until his death in 1835. When he took the judicial oath, the public hardly noticed. When he died, the nation mourned him. There was something irresistibly winning about him, said the Richmond Inquirer, and Niles Register, which had long denounced his decisions, said, next to Washington, only did he possess the reverence and homage of the heart of the American people. A historical timeline of the court. View Court History. Supreme Court Historical Society, 224 East Capitol Street, Northeast.
Excellent. Excellent. Yeah, man. Excellent bit of information. And again, we share this kind of information for honorable clarification. Yeah, man. And more time we talk about law, and whatever law is in place. But I always say, if we have a law today, it'll come from some law that was in place before. And usually, they say what is first in time is truest. Hence, we can look at the 1215 Magna Carta, which is the English Constitution, and that is not 1492, that is not 15, 16, 17, 18, or even in the 1930s. This is before that. And if we have a British head of state, then we can choose to adopt the 1215 Magna Carta as precedent for what we call common law. Yeah, man. So a document like this is going to be interesting. Invoking it into your court of record, because this is on record. And this is where I set precedents out there. Share the information about Chief Justice Marshall. I man love the law, in all its variation, in all its form. I man really love the law, because that's why I need to really get exposed to and start discover other information, and then I start share. And how I discover the level of law where we are talking about is from studying the ancient language, me like the dead languages. So I used to look at the Paleo-American language, what I'm called Paleo-Hebrew. Yeah. And I look at the Sanskritum, what them say originate from the Mayans, what them carry from here across to the east by a monk. And from that Sanskritum, they get a variation of different languages, because them say that is one of the most unambiguous language, and them now want our people have access to these things. Because with the Sanskrit, the Sanskritum, you can just create your own variation of language. And from there, I start look at the Latin. And when I start look at the Latin, and when I say look at it, I just basically familiarize myself with the foundation and the basic information. And that's when I discover law. And I start look at law from the canon law aspect. Outside of different, that's a meditation, because we have different time when we look upon information and we look upon the universal laws and all of that. But this are more, terrestrial level, where we look at where the man made construct, put in place for govern over man. So that's what we really look at. So when we say common law, it's opposed to what we would call quote-unquote statutory law, where you're being governed by statutes, which are not law. or as most people would say, admiralty, maritime jurisdiction. You know, we just say everything is about contract. It's all about contract. And you can choose to consent to voluntary or involuntary servitude, or you can choose not to consent to voluntary or involuntary servitude. So here we just share information. We reach a point now where we just say, the best way that fit, you know, aid with people, just share the information and allow them to do them due diligence and make them approach accordingly. Opposed to a try, excuse me, I got dictator, I tell her once, say, do it this way or do it my way. Because my way and my interest not necessarily match up or conducive to our next man out there. Hence, we just share basic information where people can look and take whatever they need according to their situations. Everybody are not the same. Everybody don't necessarily feel the same pain. Probably when most people are laugh, a man like I probably are cry. Yeah, literally. And vice versa. If me probably a cry and a full joy this thing, then we probably can look out there and say others a weep and a mourn. So when we say common law, we are say relative to the statutory laws or the statutory policies. That's a more appropriate way. Because once it's statutory, it's really policy. Governed by consent. Law is really unwritten. You know, if you tell a man, say, boy, you know, don't do this thing because it's wrong. Because the moment you become cognizant to yourself and you read and write a thought, or even when you don't, you're going to know right from wrong. And this is where we say free will exercises, you know, necessary. Because you're going to have to choose. And we always, I say, and I promote, choose good. Irrespective of how we may seem, or even how we are. I am on love for say, let truth reign, those the heavens may fall. Let truth reign. So irrespective of the distraction, irrespective of the, you know, conversation, truth will always reign supreme, irrespective of how it seems. Truth will always reign supreme. So when them say the pen is mightier than the sword, yes, because the foreign man come with a style where, you know, deceive our people. And them come using the pen. This is why we have people that say if you know, register your property with the state in order to pay taxes, then you know qualify for own property here on this island we call Zamayaka, now known as Jamaica. And I beg to differ, and I will go in any court and challenge any corporate construct that I will never have to register no property with a foreign construct in order to gain any kind of validity. Why? Because as a sovereign man in a sovereign state capacity, there is nothing higher. And irrespective of the presumptions of the corporate construct called a government, they are subjected to I in a sovereign state capacity as man. They are only creation of I in a sovereign state capacity as man. And when I say that, I mean one of the people. Because it's always we the people. It's never we the citizens. So when people use terms like citizens, it demonstrates the level where ones are. Because when you're a slave, you know, you can only think like a slave. You'll only have concerns of a slave. But when you're a free man, it's a whole different thing. You're not necessarily concerned for just yourself or your immediate family per se. You kind of share information straight across the earth, where anyone would choose can just say, hey, let me use a little line here or a little line there or a phrase here, or this idea can lead me down the path of research to discover so much other wonderful things. So this is why we just choose to share information above anything else. We don't mind the criticism, whether it's constructive or not. We don't mind it. We don't mind the name calling, whether it's valid or not. What is important is what we put on record, like a document where we have in place called the Superior Court of Record. Those documents stand as law. And, you know, I'm not fair guess. I'm saying challenge it. So from a sovereign West Indian's point of view, we are saying we don't necessarily have to assimilate with the foreign construct in order to, you know, demonstrate our existence. We are saying we don't need no official or unofficial validation from no foreign construct to demonstrate our existence. We are saying we don't have to engage or intertwine into commerce in order to validate our existence. Or them kind of point of view, this sovereign West Indian man I bring forward. It's not a tit for tat or a back and forth type of thing. It's about philosophical reasoning. Yeah, man. On a level where down to a grassroots people when I read and write can say, yo, what am I talk about? A war. Which part in there? Yes, up on the island. Oh, we don't know them man there. Yeah. Oh, you don't know them man there. Oh, you not get them reasoning, yeah. Oh, you not have them truth, yeah. What is precedent? Yeah, man. Precedent, I went something for the first time, you know? Yeah, man. Them saying in the early 15th century, previous instance or circumstance which may be taken as a rule in subsequent similar cases. Precedent. Listen, forgive my butchering of the words. Forgive my pronunciation. Again, we are the neophyte here. You know what I mean? We are the student here. We are the beginner here. And we are totally receptive to learning. So forgive our butchery, mispronunciation, or even our error. Just forgive it, because we never get institutionalized. You know? And we are still a work in progress. So again, we say precedent. Yeah, man. Can be a custom, a habit, or rule established. Yeah, man. Preceding in time, previous, former. Yeah, man. So when we talk about precedent, we have to say first in time is truest. I set precedent for everything that come after. Yeah, man. So them reasoning upon this level and on a dumb boy thing. And we not have to be no intellectual scholar. Yeah, man. It's just a reasoning thing, man. And this is our level. We not limit ourselves only because we choose to be free. We not restrict ourselves only because we choose to be free. And any association a man chose, he have that free will to exercise just that. Any association. Yeah, man. And as man, you can affiliate yourself with numerous associations as man. You can choose to be a Rastafarian here from the house of the Baba Shanti. Yeah. And you can still choose to participate as a Nyabingi. And you can still choose to participate as a Christian. And you can still choose to participate in any other organization. It's just where you choose to place your allegiance. Which part you put your truth. Do you have any truth? Yeah, man. Remember, free will are the gift from the Creator. And you have inherent right of liberty. And this is why you call the original Charter of Liberties, which is the 1215 Magna Carta. And this is what we are talking about when we talk about King John. I'm going to throw a tape up with King John. Them things that they don't get much views because, them things that will fly over people's head. Our level will fly over people's head. But so the Baron, yeah, where would I represent some attorney, juke down the king and I say, watch ya, we're not in a this and we're not in a that. And the king I say, well, I say, man, then I saw it for go, man. But the Pope I say, watch ya, we don't even in you in a king, because look like you sell out our thing. Remember, Britain did that there, England did that there, with the people, And then the next foreign people come in a place, in a 1066, call it Norman, me call them the Northman. Some other man will call them even the Vikings. But people ignore them kind of information, yeah. So when we talk about law and I deal with court matters and I go in a court, a man like I find some subtleties where I don't mind, express it in my approach within my court. Because the moment I place any document on, you call it, file, then I open my own court. So we have, our court is there. In other words, Babylon have them court here on the island. And when I walk in and out of them court before I actually place any document on the court record, it was just a verbal sparring where I step in and I chant some things and, as a neophyte, always as a neophyte, because we always learn. And a lot of discussion with a lot of different resident magistrates, because that is their official capacity when they are in an administrative, either say setting or venue. So the moment them in an administrative setting, they are really, resident magistrates. But we can give them some respect and call them judge. You know what I mean? We can even say honorable. One thing we show respect straight across the board, and it not cost with nothing for call you majesty, for call you my lord, for call you my king. It not take nothing, man. Because that is how we demonstrate our respect. We ahead of time. So when we're going to the court, and I'm on the back and forth discourses and thing, and always I walk out. I tell our first lady, say, listen, you see, first time or the first few time I'm on a go court on the island, what was it, 19 or 20? Every time me I go court people, I'm well prepared for jail, I kid you not. When you see me in a court, I go have on, a shorts or 2 shorts or, my marine and my t-shirt and my shirt, and it's like me I say, if them boy lock me down, at least me can have something for change off in for a few days till me get settled, so you don't know the process. And the time when me not really, well, after a while, too, me start walking and out, me start prepare like that. So when the Honorable Chief Judge Chester Crooks give me psychological evaluation and send me directly directly to General Penitentiary, now called Tower Street Adult Correctional Center Facility, something like that. I'm quite aware that the Chief Judge had the option of allowing me to visit, you know, the very same Dr. O who had a practice right here in Pines area, Portmore. He had that option, but I guess me have to get punished because I talk too much. And, you know, me still did learn a lot of things. So I just go and pay for learn, and me still not have no bitterness. You know what I mean? Yeah, man. Still respect the Honorable Chief Judge Chester Crooks and a lot of other honorable resident magistrate and judges out there. I come across quite a few. Yeah, but if you ask them probably say, man, nothing like that. Yeah, while the true ones, the roots one, them are going to say, yeah, man. Yeah, man, that man, they're not easy. You have to watch him. That's what the judge them will tell you, you know. Yeah, you have to watch, don't make him speak. Because I remember after a while, I'm going to half-a-tree criminal court with a lady. I don't remember her name, because I'm not going to lie. Them time I'm not really, you know, keep track. But through me have the case number and every court, I'm going to go after a while, I place documents so I can always retrieve the information later. But this was when them charged my witness, Jatibo, with recording in the courtyard. I'm never there inside of the court. He has never been in never there in the court at the time. He was outside at the traffic court. So them charge him for video and we'd have to go court, criminal court. And at the time, them charge me for forgery and fraud because I endorsed my driver's license that I had at the time and a birth registration form that I had at the time. And all I remember that beautiful judge was shouting is that she get her authority from the Governor General. I'm a totally comprehend what she mean, according to the documents I'm placed within the court, or upon the court, or within my court. And it was very interesting. Yeah, man. That lady was animated as mess, but beautiful. Yeah, man. And respectful, really. There's only one resident magistrate I had issue with when you're talking about respect, and that's, yeah, the Trinidadian lady. Outside of that, everybody else was patient with me, you know. Probably curious to see what I'm really on about. However, when we are talking about law, and we are talking about precedent, and we are talking about the authority of these public officers, then a man like I can look to all the documents such as this and find it interesting, knowing I can choose to invoke such a document, adapt such a document, you know what I mean, and make use of such a document. And if I can do it, the bright ones them out there surely can, because this document predate everything where they're in place now. And it applies to the mainland. Because from this document, everything proceeds from. So them kind of information, yeah, and them kind of level, yeah, and them kind of reasoning, yeah, basic. However, there's a lot of new thing and, you know, tax this and tax that, and I overheard a brethren I say him have over $1 trillion in a tax credit. I think it's supposed to represent money. And him gave away most of it and him keep 30 million tax credit. I can't say dollars. And me I say, well, it's very interesting, you know. Yeah, but I would love to see some of those tax credit reach some people where we can see the effect. Not just all like I go to a imaginary construct saying it, you know, do all kind of things. So, we, you know, we just can't wait for see the plethora of people we step forward and, you know, I say, yeah, man, this thing, you know, work and this is, you know what I mean? That's what I'm hoping to see. However, until then, we just keep doing our own thing, our own way, using a machete and maintaining our freedom, because we're done free. So all we have to do is maintain this thing, protect this thing, secure this thing. And we can safely say, I say we're under attack where YouTube is concerned. Yeah, man, we can see it. Because some video where me I get some copyright strike from, not have nothing to do with nothing at all. So them send a video with naughty audio, and when me I play the video, all it I talk about is the Maroons being foreign and, you know, the foreign construct. Just like how I talk, basically, whenever I even use the word sodomite, whenever I even fuss or not like that. I'm going to say we get a copyright strike, I'm going to laugh and I say, boy, I'm quite sure them are going to try shut down this platform, which it not make a difference to me. We're going to always find ways to share information. And I don't mind I go, you know, behind the scenes and go underground if I'm forced to. But I think the best thing is for have a man like me up front where at least when I speak, I can gauge, you know, where we are, where we are trying to do, where we are trying to go, opposed to totally in the dark. And I fear wonder and I guess. But either way, we are live our best life, truly. Right now, at the best time of our life. I've never been on this level or in this situation or in this capacity. You know? Ever. So it's like a renaissance. It's like a rebirth. It's like a, you know? So I have to say salute to my first lady out there. Because I tell you, when you talk about inspiration, yeah, man. Yeah, man. When you talk about, you know, correspondence, like speaking, yes. A damn thing there, you know. I find some me a comedian, because I've never given so much joke and laugh at myself and, you know, act so silly and loving it. Yeah, man. So I'm gonna choose to live my best life only because we know say it's always another most I create as an. It can be here today and gone tomorrow. So I choose to live my best life every day. Yeah, man. Much higher level in the people. Me are telling you in the people. And this is why me kind of move away from this group WhatsApp thing. I still have plan to open up that thing and try share some information and bring a little local community with a few other ones then together. But I still have this year's, you know, yeah, and you know, sometimes you open up your place to people and, you know, you probably create more harm than the good way you try to create. You know what I mean? You have a lot of people where them come around here and you share information, and when you look, you see other groups demonstrate things where you naturally share and smile. And next thing, I don't want a group of ones where all them do is just, you know, hang around. To me, that's like loafing. It's like a group of loafters. You understand? You just hang around and just hang around and just hang around. You don't really want to do nothing. You get me? If you learn, you know, signal say yes, you learn, and this is the appreciation for your learning. You know what I mean? If it's even, I appreciate them information here and it's edifying to I. It not cost nothing for that. Sometimes that alone is encouraging. But if you're in an area where you create a group and you're not even want to get that from the group, then you have to question it. If when you step out and you say you have a group where you try rare with them choose to be a part, and when you step out, you're alone out there, the group is somewhere hiding, then, you know, it defeats the purpose. And this is why I'm not mind a share and structure, but you know, go have me a group up with y'all and then, you know, you end up in a GP prison and it's only probably Clan Mother Annan, you know, Jaguar Dimitri, you know, Sir Anthony, Iron Eagle. You understand? It's just really them people there. And when I say that is a handful, when you have almost 200 people in a group. And when you lock up on things, you never hear no kind of indigenous, aborigine, or American Indian community say, hey, welcome to the sovereign man on the island. I never heard that. And this is why I just keep maintaining and know. So I not do this for no clout or no popularity or no fanfare. I do it only because of the ancestral spirit where animate me. Because if it's up to me, I would even come out here, come look on somehow and even chat. But if this voice weren't here, what would I know? You know, 10 years from now, before would I get there? Because remember, you know, I have done something here on this island that has never been done before. It's called setting precedent. You get me? Yeah, man. And when I say it this way, it's only because we not ask nobody no permission. We not submit to no foreign power. You understand? These are the subtle differences. You know? When I man say I sovereign in high capacity, I can demonstrate that. I can prove that. And I can go into any one of your superior or supreme court and be victorious. Only because truth supreme. Who can rebut my truth? Don't talk. Take me in your court. So them kind of energy, them kind of clarity, them kind of truth, Your legal process and your forms and your formality cannot apply to a man in his sovereign capacity because the court only belongs to the sovereign man or woman. It belongs to the sovereign. And a judge within any court is a public servant / public officer. Yeah, man. I am that boss. But them not like when you go on arrogant with it. Them want you to be subtle. And them want to make sure you have knowledge. That's all it is. So when someone say, hey, it's not an individual thing, this is why most people are in trouble. Because individually, they not choose to arm themselves with this kind of knowledge, correct knowledge. Is you, I forget the information, because you going to keep that information, and anywhere you go in the earth, you're going to carry that information with you. This is how you choose to free yourself. Because only you can do that. With the actions where you choose to make. Philosophical reasoning, people. Yeah, that one you probably get some kind of imaginary copyright strike and block, so it look like my thing I go on, my information topple empires. It's not no popularity thing. Yeah, man. It's not no, you know, I forget X amount of views and like. No, the information go out in the earth like a ripple. And that ripple effect goes straight across the earth and take on life. Because this is our truth. Sharing of information. Higher level people, give thanks, give thanks, give thanks.